So as you can see on my screen, my presentation today will be on the CARIFORUM legal framework for geographical indications and trademarks. So let's get started. And I won't take anything for granted in terms of whether everybody understands what we are dealing with in terms of territories. The CARIFORUM nations, as you can see here, it's Antigua and Barbuda, the Bahamas, Barbados, Belize, Dominica, Dominican Republic, Grenada, Guyana, Haiti, Jamaica, St. Kitts and Nevis, St. Lucia, St. Vincent and the Grenadines, Suriname, and Trinidad and Tobago. So I'm sure that there are many of you here today who are actually located in these countries. I myself am located in Belize. And so I am a part of the structure of which we speak today. And as you can see as well, just by a glance, the nations are so diverse as it relates to the CARIFORUM nations. They have their own jurisprudence. They have their own legal systems. Some of them have Spanish backgrounds, British Commonwealth backgrounds, French, Netherlands. And so we know that they all vary greatly from territory to territory. But what is a uniting factor for a lot of these territories is the fact that many of them are signed on to treaties and agreements relating to intellectual property. And by virtue of being contracted to those treaties and agreements, they have similarities and they have similar obligations which they have to integrate into their own legal systems as a result of that. And so because we have so many countries and because we don't have a lot of time today to cover in detail each of them, I will touch on the higher level frameworks, what has influenced the national frameworks. But of course, jurisdictionally, there will be differences. Territorially, there will be differences. And so for attorneys who are interested in their respective territories, you would have to maybe do a little bit more on the ground research with your IP office to understand where your country is at this point in time and what registration systems and so on are available to you. So let's start out by looking at what treaties are in common for all CARIFORUM states, which cover GIs and TMs, which I'll use for short as it relates to geographical indications and trademarks. So of course, we've had very extensive discussions already relating to the EPA, which is the EU CARIFORUM Economic Partnership Agreement. Tyra, she touched on articles 144 and 145, which I would encourage you to take a look at if you have the time. We also have the TRIPS agreement, which was touched on, and we have part 2, section 3 for GIs, and my apologies, I've left out the section reference for trademarks there. We also have the Paris Convention for the Protection of Industrial Property. Industrial property, of course, will cover your trademarks, geographical indications, industrial designs, etc. So everything was kind of consumed under that particular convention. I am going to skip. I know that you received extensive homework in terms of preparing for this, this workshop, in terms of making sure you understand what a trademark is. We also have to look specifically at collective marks, which indicate membership with a group, and certification marks, which indicates that you meet a certain standard when labeling goods or services. We'll also take a look as well at other important trademark treaties which influence the CARIFORUM states, and those include the Nice Agreement on the classification of goods and services for the purposes of the registration of marks. We call it the Nice for short. We also have the Madrid Agreement concerning international registration of marks and the Madrid Protocol, which goes along with that. We have the Singapore Treaty on the Law of Trademarks, which ties in a bit or adds to what you see in the bottom right-hand corner, the Trademark Law Treaty. We have the Vienna Agreement establishing an international classification of the figurative elements of marks. And then we have the Nairobi Treaty on the protection of the Olympic symbol. So as you can see from something as simple as the Nairobi Treaty for the Olympic symbol, as I said, these treaties and agreements and conventions are uniting factors to say, okay, we know you have different laws, we know you have different systems. However, as it relates to these particular areas of intellectual property, we would like to harmonize as best as possible as many legal systems as we can. And so CARIFORUM states have been impacted by these, and we're going to take a closer look now on exactly how that has occurred. So I did some research by way of WIPO's website to take a look at where we are with our treaty and agreement accessions. Well, I will call it contracting, because different territories are at different points in their accession or their ratification of these various treaties. What I have looked at mainly here is whether they have contracted. The contracting means that they have signed on to it and indicated an intention to accede, to ratify, and to align themselves with the intentions of those treaties or agreements. And so you can see, as it relates to the Nice agreement that covers how we classify our trademark applications, we have several states that have acceded or have contracted to the Nice agreement and are therefore using the exact Nice classification in their laws. Then we have others who, even though they did not contract to the agreement, they have aligned themselves or partially aligned themselves with the Nice agreement. So I can speak for Belize. Belize, as an example, has always used the Nice classifications, even though it is not party to the Nice agreement. Just in September, Belize has switched over to the TM classifications. And so that includes Nice plus more. And so even though there is no accession to the treaty itself, we continue to use the same classifications. How that helps in practicality is that if a client wants to register in several territories, they can, for the most part, provide one set of classifications, class descriptions, and we would be able to adapt it as close as possible, if not identical, from country to country, so that the protection of the trademarks are uniform as much as possible from country to country. And then we had the Madrid Protocol, which has to do with allowing for the international registration of marks via WIPO. Of course, it has a lot of controversy or disagreement from private practitioners because of its the way that the system would work. But we do see that there are states, CARIFORUM states, that have signed on to it as well. The Vienna Agreement, we do see as well that there are a couple who have signed on. The Singapore Agreement, the same, and the Trademark Law Agreement, the same. And with the Singapore and Trademark Law Agreement, they match because they are widely based on one another in terms of how one has built more into communications, technologies, etc., as it relates to the other. And so you already know as well what a geographical indication is. And one of the biggest points to always remember is that it implies the presence of a special quality, reputation, or characteristic of the product, essentially attributable to its place of origin. And so we have, as it relates to GIs now, we have, as was mentioned prior in the prior presentation, we have the Lisbon Agreement with the follow-up Geneva Act of 2015 that speaks to the protection of appellations of origin and their international registration. We also have another Madrid Agreement, but this one is for the repression of false or deceptive indications of source on goods. And then we have the Paris Convention, which we have already discussed or mentioned. And then we have the Madrid Protocol, which we have already mentioned as well, but just to say that they do touch on GIs as well as trademarks. So again, we take a look at what the status quo is in a way as it relates to contracting states and the GI treaties themselves. So what we see here is a very, very clear indication that as it relates to GIs and the treaties that are in place through WIPO in particular, we do not have regional or CARIFORUM support per se of those treaties. Now, I suppose the reasons for that kind of, this kind of result is it can be varied. One of the reasons that I have looked at as well is that through the TRIPS agreement and through the EPA, a lot of the obligations relating to GIs, the protections of GIs and how best to create the systems for their protection and enforcement have been included in those treaties. We know that a lot of Caribbean nations can be a bit hesitant, or many nations in general can be hesitant to sign on to too many treaties which may bring obligations that they are not necessarily able to keep up with. And so sometimes in looking at what the actual obligations are under one versus the other, there may be a decision from the IP office or the Ministry of Foreign Affairs to sign on to one, which basically covers or includes a lot of what is included in another. And so that could possibly be one of the reasons why we see this trend in terms of not having contracting CARIFORUM states when it comes to geographical indication treaties. However, when we take a look at countries in CARIFORUM that have some sort of GI legislation, and when I say GI legislation, I mean that they have somewhere in their laws provisions specifically on the registration of GIs and enforcement of GIs. We see that the number of countries here that have that dedicated GI legislation or dedicated GI provisions in force, it doesn't actually match when we look back at the countries in the prior slide that had not signed on to some of the more prominent treaties as it relates to GIs. And so that kind of proves that trend or that point that we were speaking about, where we are looking at the fact that more than likely these countries have encountered the obligations relating to GIs from their other treaties, their other conventions, such as the TRIPS, such as the EPA, and it is for that reason that they have provided for the provisions necessary without necessarily going into dedicated GI conventions and agreements specifically offered, like the ones that I have mentioned in the prior slide. And so when we speak about CARIFORUM state, which is considering national GI legislation, the general goals for any state will be, or is for those who already have it, one, to provide a registration system for producers of goods to use a GI in relation to those goods. So it's important to mention here when looking at this goal that we're speaking about a GI being able to be used by producers of the goods to which that GI relates, right? So we'll get into a couple of the distinctions a little bit later, but really and truly, what we're looking at here is that there are groups of producers that are generally able to say that I am producing a good that matches the reputation, the characteristics of this GI, and therefore there is an entitlement by way of registration to use those goods. And secondly, the goal should also be that there is a system for enforcement against the unauthorized or deceptive use of GIs. And then even in having these national systems where we are looking at the protection and the enforcement for those who are based in that jurisdiction, we have to remember that by signing on to some of these conventions, treaties, and agreements, we are in essence giving or committing to reciprocity, that we will treat the rights equally, that if the EU, for example, has a registered GI, that we also respect that GI in terms of how we handle and treat our trademarks and our GI structures and mechanisms. And so when we speak about GIs in general, a single criterion, as has been said before, attributable to geographical origin is sufficient, whether it is a quality or other characteristic of the product, or even just its reputation. And so this is to be distinguished from a type of GI, which we call appellations of origin. So appellations of origin are a special kind of GI. As mentioned by Rebecca before, we don't really speak so much about the distinctions, as they kind of all come under GIs, and it tends to be the same for us. We do say GIs and appellations of origin, but the appellations of origin are a special kind of GI. And the difference here is that the link with the place of origin must be stronger than that of the GI. The prior slide said a single criterion is acceptable, which may just be reputation based. However, when we're looking at the appellations of origin, we're talking about the fact that the quality or characteristic of a product protected as an appellation of origin must result exclusively or essentially from its geographical origin. That is, the raw material should be sourced and the processing of the product should be done in the place of origin. And so that is one of the distinguishing factors that we look at when we speak about national frameworks and how it would integrate the GI definition versus the appellation of origin definition. And so let's take a look at the regional forerunners for GI registrations. The Dominican Republic is definitely quite a good example for us to take a look at. They have several GIs registered, including Cacao Dominicano. They have Los Bejucos, which is a type of dark chocolate as well, dark cacao, which they use for their chocolate. The Café de Valdesia, which was mentioned by Alexandra in her opening remarks, that is a coffee. And we also have Jamaica, which has Jamaica Jerk, Jamaica Rum, and Jamaica Blue Mountain Coffee is either already registered or very close. I know that Lily Claire is in the room and will be moderating tomorrow. So I'm sure that we will be able to hear a bit more about what's happening in Jamaica as well. We have the Cuban cigar from Cuba, which has been registered through Cuba. Trinidad and Tobago has registered Trinidad Montserrat Hills Cocoa. And then Guyana has registered Demerara Rum, which is also registered in the EU. And so you can see that there have been movements in the region for us to have recognition of our own types of geographical indications. Of course, that means that these countries would have to have had their legislative framework in place in order to process these sorts of registrations and to ensure that after the registration is effected, there is more than enough provision for effective enforcement once persons use it in an unauthorized manner or use it to the damage of those who have the true authority to use it. And so we have these examples and we hope to see many, many more to come. I know that Belize is also considering. We have lots in the air from different CARIFORUM nations, you know, we have nutmeg in Grenada. Belize also has is looking at cacao, and many others. So, you know, there's still a lot to come from this area in the region, but we do have to realize the importance of being able to handle the obligations that come with it, because it's a whole new system that we need to be able to ensure that we preserve the value of these assets once we put them in place. And so now we look at the cross-section of GIs and TMs. So many trademark legislations in the CARIFORUM states contain provisions which touch on the use of signs or words which indicate geographic origin of the goods or services being registered in association with a trademark. Now, please remember that this is different from a GI, which has its own registration and system. What we're looking at now is the cross-section and the interrelationship between trademarks and GIs. And so when we look at Belize, for example, the Trademarks Act in Belize expressly prohibits the registration of trademarks that exclusively consist of signs indicating, among other things listed, geographic origin. However, there is what we could call an exemption, which is collective and certification marks. The schedules, Schedule 1 and 2, if I remember rightly, of the Trademarks Act, when speaking to regulations of how to apply for collective marks and certification marks in Belize, allows for certification marks and collective marks to consist of signs which indicate geographic origin of the goods that is being attributed in that application. However, there is a proviso. The proprietor of the collective mark or the certification mark cannot prohibit the use of the signs or indications in accordance with honest practices in industrial or commercial matters, in particular by a person who is entitled to use that geographical name. So as you can see, Belize has its own interpretation, its own way of dealing with this cross-section. Other countries will not have that ability whatsoever. Some may go a little further, some may withdraw even further from what we're seeing here with Belize. And so we also know that CARICOM countries are obligated to strengthen regimes for the protection of intellectual property rights, amongst other actions. For example, Article 66 of the revised Treaty of Chaguaramas, which establishes CARICOM, including the CSME, speaks to intellectual property rights. Also, Article 4.2N of the revised Treaty of Basseterre, establishing the OECS Economic Union, also speaks about the need for the OECS nations to have their intellectual property rights systems taken care of, their mechanisms in place, strong mechanisms in place. And then, of course, as I had mentioned before, the reciprocity comes in with the second point on this slide. Additionally, CARIFORUM and EU countries through the EPA are required to reject applications for trademarks once that proposed trademark includes characteristics identical with, similar to, or containing a registered GI. And so you can see that at Article 145D of the Economic Partnership Agreement. So you can see that there are the rules that go with these agreements, these obligations that we enter into, and each country then has its responsibility of ensuring not only that its laws reflect it, but also that the practices of its IP office and other authorities involved reflect and honor the provisions of the treaties to which they have contracted. And then my final slide, we are going to just quickly take a look now at the distinctions between GIs and trademarks that influence all CARIFORUM states' legal frameworks. And of course, you can see the very basic ones here. GIs identify a good that comes from a particular place. Trademark is from a particular proprietor. The GI can be used by any person in the area of origin who produces a good according to specified standards, while the use of a trademark is exclusive to the proprietor in the jurisdiction and may not be used by another without authorization. The GI, due to its intrinsic link with the place of origin, cannot be assigned or licensed to someone outside of that place or not belonging to the group of authorized producers, while a trademark can be assigned or licensed to anyone anywhere in the world because it is obligated to be linked to a specific proprietor and not to a specific place. And then finally, the name used as a GI is usually predetermined by the name of the geographical area, while a trademark often consists of a fanciful or arbitrary sign and actually cannot be descriptive or generic. And as we've mentioned, usually cannot mention the geographic origin within the sign itself. And so with that, ladies and gentlemen, I'd like to say thank you so much for your attention here.